Okay, let's jump right into this explainer. Today, we're unpacking a massive, landmark constitutional court ruling. It's one that literally tests the very limits of human liberty and societal safety. We're looking at a set of cases that fundamentally challenged how a democratic society actually handles the whole concept of bail. It's a fascinating, kind of intense look at what happens when the absolute right to personal freedom collides head-on with the urgent need for public security.
So this brings up a really profound moral question. Picture a nation grappling with a skyrocketing violent crime rate, right at the exact moment it adopts a brand new, highly protective Bill of Rights. On one side of the scale, you have the presumption of innocence, but on the other, you've got a terrified public desperately demanding protection. Should the sheer anger and outrage of a community be enough to keep someone locked behind bars before a judge has even found them guilty? Keep that question in the back of your mind because it's the absolute beating heart of the legal battle we're exploring today.
To make sense of all this, we're going to break it down into 5 quick sections today. First, the bail dilemma. Second, setting the new rules. Third, separation of powers. Fourth, the public outrage factor. And finally, exceptional circumstances. Let's get into it.
All right, Section 1, the bail dilemma. We really have to start by looking at this massive crisis of confidence that hit the lower courts during the transition to a constitutional democracy. Judicial officers suddenly felt like they lost their sure-footedness on when to actually grant bail. And it all boils down to a crucial pivot in the Constitution, specifically Section 35(1)(f). The baseline completely shifted. Under the old rules, an arrested person was basically automatically entitled to bail, unless the state could prove they shouldn't get it. But the new baseline, it dictates that an arrested person has the right to be released only if the interests of justice actually permit it. So we went from this automatic entitlement to a very heavily scrutinized weighing of justice, a real game changer.
Moving on to Section 2, setting the new rules. So instead of looking at these 4 major cases in isolation, the Constitutional Court decided to group them together. We've got Dlamini, Sheetakate, Jabert, and Ladla. Each of these individuals committed very serious, violent offenses. We're talking everything from murder to child molestation. And each brought their own unique constitutional challenge to these strict new bail laws. By viewing them as one cohesive story, the court was able to comprehensively test the entire legal framework of bail all at once.
Okay, Section 3, separation of powers.
To really grasp this conflict between the legislature and the judiciary, we've got to define a central concept here: the interests of justice. The court determined that evaluating this is a delicate and entirely mandatory judicial function. Basically, it requires courts to stop acting as passive umpires just waiting for lawyers to make their arguments, and instead forces them to actively balance the scales of justice themselves. The judge has to proactively weigh the personal liberty of the accused right against the preservation and safety of the community. And Section 69 of the amended law kind of physically manifests those scales of justice. On one side, you have societal interests, like is there a risk of the accused fleeing, tampering with evidence, or endangering public safety? But directly opposite that, you have personal interests. The accused might suffer total financial ruin, their health could deteriorate in prison, or they might not be able to properly prep their defense. The judge literally has to weigh these exact competing factors against one another. Ultimately, Justice Kriegler, who was writing for the court, completely rejected the argument that the legislature had overstepped its bounds. The court ruled that these new laws absolutely do not violate the separation of powers. Why? Well, because they aren't rigid rules forcing a judge into a corner. Instead, they're essential, helpful guidelines for the judiciary. At the end of the day, the final decision still rests entirely with the judge's evaluation of those scales we just talked about.
Which brings us to Section 4, the public outrage factor.
The facts in the Sheetakate case are, frankly, incredibly grim. We're talking about a repeat offender with a 14-year history of pedophilia. And shortly after being released, he was arrested again for assaulting a 3-year-old girl. The magistrate denied him bail, citing the severe risk he posed and the immense shock and outrage his release would cause in the community. But the defense immediately pushed back. They argued that letting community outrage dictate bail is basically a form of lynch law, one that completely ignores the accused's right to the presumption of innocence. This forced the court to confront a highly uncomfortable question. We really have to ask ourselves, is elevating the raw anger of a community above the constitutional rights of the detainee ever acceptable in a democratic society? Does the threat of public disorder actually justify keeping someone locked in a jail cell before they've even had a fair trial? Well, the court answered yes, but with some major caveats.
They acknowledge that considering public outrage is, for sure, an infringement on an individual's absolute liberty, but they ruled that it's actually a reasonable limitation, especially given the country's severe reality of widespread violent crime. Sometimes, temporarily withholding liberty is a constitutionally necessary step just to maintain public peace and preserve the public's confidence in the justice system. But, and this is a big but, it is only to be applied in truly exceptional situations.
Finally, let's look at Section 5, Exceptional Circumstances.
To cut through some of the legal jargon from the ruling, when the law mentions a Schedule 6 offense, it's specifically targeting individuals accused of the most destructive, organized, or exceptionally violent crimes out there. We're talking premeditated murder, violent rape, and syndicated violence, like those deadly taxi industry wars. The legislature designed what is essentially an escalating burden of proof. For ordinary crimes, the court just balances the standard factors. For Schedule 5 crimes, the burden shifts a bit, and the accused actually has to prove their release is in the interests of justice. But if you're charged with a Schedule 6 crime, the baseline assumption is that you are staying in jail, period. You have to prove an extraordinary, exceptional circumstance to even be considered for release.
Which brings us to the D. Laudla case. D. Laudla and his co-applicants were charged with 9 counts of murder related to a violent taxi war. Because this was a Schedule 6 offense, that massive burden of proving exceptional circumstances fell squarely on their shoulders. And to make things even harder for the defense, the law legally denied them access to the police docket during the bail hearing, just to ensure they couldn't tamper with witnesses or evidence. The Constitutional Court upheld all of these strict measures. For violent syndicates, making bail incredibly difficult to obtain is seen as a constitutional necessity to prevent further violence, witness intimidation, and honestly, the potential collapse of the justice system.
So we'll leave you with this final lingering thought on those scales of justice. How does a democracy perfectly balance the sacred constitutional right to human liberty with a desperate, urgent need to survive violent crime? There are definitely no easy answers, but as the court demonstrated, it requires a constant, active weighing of the scales. We hope this explainer has deepened your understanding of the incredible complexities, the intense legal battles, and the profound moral questions behind the seemingly simple act of granting bail. Thanks for joining us, and we'll see you in the next explainer.